Many kids who are relying, and by state law, those services need to be provided. So I think those are fair questions. And I addressed before that I know that Ms. Winters, upon receiving those emails, has asked individuals to provide information.
I think,
through the chair. Can you just address?
Through the chair, yes.
Mr. Simmel, we need to stay on one topic, and let's finish. Let board members get answers on their questions. Mrs. Winters, please go ahead.
We are currently understaffed in the business office at this time,
Okay.
and I'm not going to sit here, Mr. Zimmer, and discuss employees in the public session.
Nor would I suggest that you do that.
Okay, but you're saying there is the staffing problem. That's something the board should review. Would you recommend for the board, because the board does the hiring and decides the policy, upon your recommendation for which personnel to hire? Would you recommend that we should, at the next meeting, discuss? Because that is something that we need to show the public that we have the manpower to provide essential services to make sure the kids are safe.
Isaac, if we were able to have a quorum at the next meeting, we can make that happen.
Okay, thank you, Tracy. So, Ms. Winters, you would think that we should discuss that at the next meeting? You make a recommendation in terms of, and put out ads, that we should have more people in the business office so things could get done on time. And again, it's not just getting done on time. We have a legal obligation by state law. We have a liability. What happens if a child in the room has a diabetic attack, or a child who has severe allergies has an attack? Those children go from regular color to blue very quickly. And those things happen in schools before. The children don't do it. This is our responsibility, and we're trying to fix it. So if you feel that the business office is understaffed, please come to the board. I don't think the board turned away any recommendations from you in the past.
We actually have advertisements out for our staff members, and we don't get resumes. So we are in the process of looking for employees, quite honestly.
Okay. So I think it's important that the public knows what's going on. I think found out that we're understaffed. Anybody else has any other question on nursing? So just to clarify, the nursing contracts went out, and when will the services start? Does anyone shine light on it?
They should start immediately, and as far as I understand, there is actually a nursing company who is actually providing nursing currently and has all week, so. Yes,
All right.
they have a large
Any
majority
other
of
question
schools.
on the nursing services? Board members? The chair? Yes, go ahead.
I think it's important for the public to know, I think it was brought up before, that the Board of Ed in general does not get involved in the day-to-day, not in the nursing decisions, this is done through the administration only. It comes to our attention a day beforehand, and I'd like to commend the President, Mrs. Lochner, for calling this emergency meeting.
Again, we heard a comment from Mike that there's a tape and it will be reviewed, it will be listened to. I would like to make sure that Mark, please step in if you feel that anything that's being said is an area that we should not go into. Okay, let's continue on to the next topic, which I think we need to discuss, the IDA services. There is a school STARS that has not opened. There's over 150 kids that have IEPs. Those kids are protected by federal law. Those kids are protected by the federal law. They have an obligation. They have an IEP. The district has to provide the services. There is no contract. So when I'm getting very concerned that we don't have the manpower to do the contracts and the people to get to the attorneys to respond with some of the questions, with some of the material and some of the numbers that they need to get. And because of that, it's a liability on the district. It's a liability on the district, and we're not providing children who are underpriced. Children who need services, they're special ed children, and they're missing now time in school. We're starting the school later. Ms. Winters, if you could address when the IDA contracts will go out, if there's any holding up to it, when could the children, again classified, could start the services?
I sent Mr. Zimmerman an email yesterday asking if they could start immediately at sending out to Joe Roselli. I sent an email to Adina Weiss requesting that she notify all the schools and the vendors as well as I sent that to Joe Roselli yesterday as well.
Yeah, we have sent the contracts to all the vendors, and hopefully based on the contracts, which still there's going to be back and forth, I expect, but hopefully based on the fact that they actually have a contract in hand, it'll at least show the district wants to contract with them, such that they will hopefully immediately begin services as well. We'll reach out to the vendors too.
So it will be, we will start, this children will not start services tomorrow, day after tomorrow, they sometime in the foreseeable future based on the...
It's going to be
feedback from the vendors. Let me just address another point, and that is, Ms. Winters, can you clarify, is there any documentation that is preventing the STARS program or anything else from starting? Is this just the vendors? Mark, is this just the vendors that are being prevented? Could one of you or both of you clarify, is there anything else besides the vendors getting back to you and signing the contracts that preventing the IDA services from starting?
Not that I am aware of.
Ms. Winters?
I have not heard of any issues.
So only need, if Mark gets vendors, they return and they say we're satisfied or we want to make certain corrections, and you have a back and forth and the district signs, there's nothing else that prevents the services from starting.
Nothing that I'm aware of.
All right.
So can we start immediately before the contract is actually signed and finalized? Can it be up and running by Friday morning or Monday morning?
Why not tomorrow?
We have operated in the past, as long as everybody was on board, we have operated in the past without the final contract being signed. If we know the contract is en route to be signed, is there any reason to have these kids sitting at home any longer as opposed to starting school immediately?
We will reach out to the vendors to see if they're willing to start services. You're correct, Mr. Silver, in years past.
So in the
I'm sure the
interim,
vendors are eager to start.
in the interim, can we go on the past year's contract until we move forward with the new contract? I'd like to make a motion.
We should be guided by this year's contract. The old contract expired on June 30th. They have a new contract in hand. Quite frankly, they could sign it tomorrow and send it back to us and start services.
So like you said, there's likely back and forth. Why are the kids the one taking the toll over here for the back and forth between the vendors?
Fine with me.
Mark, I think what is being asked is, are we allowed, until the new contracts put in place, are we allowed, because the children are not getting services, are we allowed to start
Yes,
start
I would say yes, but
based
it's-
on old contracts? As an attorney, are we allowed?
We should rely on the new contracts that have been issued, not the old. They have the new contracts in hand. The question is, and I will reach out to them, will they commence the services based on the contracts that they have?
What is
Hopefully the answer
what
will
is
be
the
yes.
feedback you've been getting from them, why they're not starting on services?
I haven't received any feedback yet. They just got the
So
contracts.
you don't know why in the past they have done services just based on letters of intent or some sort of authorization letters, and this year they do not.
Look, I don't want to speak for the vendors, but I assume they're concerned
I'm just
about
asking, you
getting
got any
paid.
feedback?
That if they start services, they're going to be paid for them. I'd imagine that's their concern.
So you're saying that they're concerned because of all the changes that they might not get paid and render the services and then get stuck with the bill when the district might say, hey, based on this and this, you provided the services wrong.
That's probably a fair assumption.
So can I make a motion?
Based on what you said before and what Ms. Winters said before, can they be reassured tonight that there's no skeletons in the closet popping out as far as what's wrong with the services or anything else?
Why don't we make
That
a
they can start?
motion to sit on the contracts from last year until something new can be negotiated? I make a motion. Second. Roll call. I'd like to make a motion to clarify the motion that the contracts from last year should stay, and this way they're guaranteed that they'll be paid until something new is negotiated. You seem to be saying it's imminent. The kids can start tomorrow.
Yes, but Mr. Roosevelt, we don't need that. The contracts are all in effect. It just needs to be signed.
I mean, based
Maybe I
on
don't agree with
based-
some of them enough for a week.
Based on conversations that some of the colleagues in my office who've been working on these contracts had with some of the vendors last week, they simply wanted a letter of intent from the board to them indicating our intent to contract with them. My conversations with them last week were simply that if they had a letter of intent, they would start, hang on, let me finish, please let me finish. If they had the letter of intent that they would start the
Have you
services.
communicated?
Please, let me finish. Yeah, go ahead. So I'm confident, now that they actually have the contract, more than a letter of intent, much more detailed, that perhaps they will be inclined to start services. They didn't want to start services with nothing in hand. They have something in hand now.
But it's not signed, these contracts are not signed.
It's up to them to sign it.
Is there a possibility?
The question is, can they start services?
Please, let's not talk over each other. Everyone
So
goes to the chair.
can we follow through
Mr. Silva, let's
Mr.
go to the
Rosenblatt's
chair.
motion to
Mr.
extend the
Silva.
contract in the meantime? Can we follow through with Mr. Rosenblatt's motion
So
to
once
extend
again,
the contract?
make a motion. Once again, I'm making a motion to continue with last year's contracts so the kids can begin tomorrow until something is worked out.
We have a motion on the table.
I would say you have to add some language to that.
Isaac, through the chair,
One second, let the attorney respond.
Go ahead, let me just make a comment. I just would want to add language to that motion, subject to my review of those contracts, because as you know, the code changes, the law changes.
And I
wouldn't
respond-
want, can I finish? I wouldn't want the board to rely on provisions in the old contract that are no longer legal. I don't think anybody wants that. So we have to make sure that if we're relying on old contracts, that those contracts are legally compliant.
So Mark, let me get it on the record. So now you're saying that it is important to follow the law.
I've never said anything to the contrary, Mr. Rivera. What would give you that direction?
I think we should, let's
I've never said anything to the contrary.
not
Mr. Rivera.
characterize Mark Zitomer's comments, because that's not what he said. I did not, he did not even allude to that. He did not insinuate.
There's a motion on the floor to do that, to do just that.
Subject to me reviewing to
Subject
make
to
sure
the
the
attorney.
contracts are legal.
Subject to the review of the attorney. I want to interrupt you, but the attorney is the law in this district. The attorney hired by the Board of Ed, he is the law in this district. Okay, there's a motion on the floor.
But if the
Tom,
vendors, I'm gonna.
Yeah, we're gonna discuss it. Yes, go ahead,
But
yeah.
if the vendors have contracts in hand of any new changes that were made in the law, why are we gonna go back?
Casey, you're asking an excellent question, and the answer is, I spoke to one of the attorneys today, and I said, what is the time for a review of this contract? Remember, this contract has 30, 40 pages. They're $1 million contracts. The companies do not just get a contract and sign it. There's a review time. Are we gonna wait now till November, October, until relying on the fact that these companies have a due diligence to do, to review this contract? There's a lot of new regulation in there.
You're
So let
saying-
Mark, let the services start.
I understand what you're saying.
Complying with the new regulation, complying, because it's all based on attorney review, complying with the new regulation.
I don't even
This
think we're
attorney-
gonna have to rely on the old contracts, quite frankly. Like I said before, I think the contracts, now that the vendors have the contracts, I don't wanna speak for them, but I'm confident that they're gonna be willing to start services now.
Well, but they didn't start it yet. The contract-
They just got the contract.
Richard,
Yes, Mr. Schwartz.
I just have a legal question. If vendors review the contract, assuming that they start services immediately, and then they turn around and say, we don't like this contract, we don't want to work under these terms, who pays for the services that were provided up to this point?
If they're authorized by the attorney. If they're
That's a
authorized by the
conversation
attorney.
I'd have to have with Mr. Rosario, who's the CFO of the district in terms of financial oversight over the business administrator as
All
well.
board is doing that in a legal way possible, complying with all the regulation that need to be complied with. We want the service to start tomorrow. I think the urgency was extensively explained, and our obligation on the law to provide the services.
I would have to defer to Mr. Rosario as to whether he'd be amenable to having the vendors start services before the contracts are finalized. I don't know the answer to that question. That's beyond my,
There's a motion
Why
on
don't
the
we call a
floor.
roll call, and there's a motion on the floor, let's take care of that, and then we'll hear what the monitor has
What
to
is the
say.
exact wording of the motion?
Roll call comment.
One second.
Can I hear the wording of the motion?
I'm sorry?
What is the exact wording of the motion?
You made a motion, please tell us the version.
I wanted the motion not contingent on anything other than we will stay with last year's contract that the Board of Ed approved last year and let them work out this contract. But until then, they will be paid and guaranteed that, and therefore they will, in essence, provide the services starting tomorrow, without any contingencies.
Without any provisions. Through the chair, but if this is a state-provided service that the state normally pays for, don't we want assurance from the state that they'll pay for the service?
Mike, can we have a roll call? I believe that the motion that was on the floor before, that's something that the board members were in favor of.
It's my understanding, and correct me if I'm wrong, I'm going to paraphrase your motion. I think what you were saying is that you're asking that the vendors continue services based on the old contracts with no contingencies. Am I correct?
Well,
Is that what
they
you're
have-
saying? Hang on. I just want to make sure, Mr. Rosenblatt, is that correct?
Correct.
That's the motion.
Again, if the contracts...
My recommendation.
Yes, go ahead. What's your...
No, I already stated what my recommendation was, to have that subject to review to make sure that those contracts
To your review.
are legally compliant based on 2014 standards. Those
And
contracts
based
were
on the
prepared in
state-
2013.
And based on the state audit and the written instructions to the board in terms of how to conduct the contracts and the business. I agree with you.
Can you clarify?
Subject to attorney review.
Subject to attorney review. I think as...
So if they were to provide service, and then you, let's say in the middle of class, whatever, something that you don't deem to be lawful for whatever reason, and it takes time to figure out, or there's back and forth, then they don't get paid? Mr. Zara?
Again, there are clear guidelines that the state put in writing. We're not talking about something that...
These contractors are well aware of the laws and regulations. They provide services to other districts throughout the state. They're putting themselves out as experts. I have no idea why they would not understand the laws and regulations.
Okay, so Mr. Rosenblatt, would you... Mr. Zara, would you pay them at the start of the services? Based on the legal review of a mark to make sure that they comply with written instructions from the state, which are contained in the state audit, legislative audit, and all the other compliance. Would you pay the vendors if those...
I believe that the contracts that were sent to the vendors
Right.
are compliant with the laws, and I don't see any reason why they should reject it.
Well, Mr. Zara, I would love...
I believe it's in the vendor's hands right now. The board has done their due diligence.
That-
The district has done their due diligence. We've given them contracts. If they want the contracts, they'll sign them. If they don't, we'll bring the program in-house and hire our own people to deliver the services.
But Mike, they received the contract, some of them today. Mark, correct me if they received it today.
Today and yesterday, I believe.
Today and yesterday, there's a time to review 30 or 40 pages. My point is, Mike, I absolutely agree with you that I would love nothing more than not to sit here and go through this. If the contracts were sent a while ago, with the time for the vendors to review, we are in a situation, I don't want to be at the mercy of the vendors. We are in the situation now when they're reviewing it, but the children don't have services. We represent the children. We are stalling, I don't want to use the word stalling, I'll take it back. We do not providing as a district services we are mandated because we are the mercy of the, I don't want to say the mercy of the vendors, but they have the due diligence they need to do. And it takes time for any contract. So the suggestion is, could they start the services with a letter of intent that the services will be based on the prior contract unless pending, based on the review of the attorney.
I would never agree to having them work under the prior contract.
You would never agree for them to work without a contract? With
Under the prior contract.
So Mike, under the prior contract. Well, it's not a prior contract, let's not phrase it like that. It's just a framework, but it's really additions based on the audits and everything. We're not dealing with the prior contract. But Mike, I want to ask you a question. What is the alternative? Are we waiting again and again? You are the CFO. You are the CFO. You right now are running not running, but overseeing the finances. Why are tens of thousands of children are not getting services because the vendors did not get the contract? As we heard, because the business office is understaffed, and it's a serious problem. I'm not undermining it, but this is what we heard today from the superintendent. The business office is is understaffed. That's why thousands of children, including federally protected children, are not getting services.
I agree to let them start the services with the letters of intent. If there's contract language that needs to be worked out, as long as it's not non-compliant with the law,
And
I
with
don't
the-
see a problem with that. And I said last week I was okay with the letters of intent. And for some reason, they weren't good enough for the vendors.
Kids have to be in school tomorrow.
So the letters, let's just clarify, I would like to be everything on record. So you're saying that the letters of intent will go to all the vendors today, that they could provide the services. They will provide the services and they will get paid for those services. Is that correct?
That's correct.
Thank you, Mike.
School tomorrow. The kids have to be in school tomorrow.
Well, I think that's what we heard right now from Mike, that tonight, all the vendors will tell their, based on the letter of intent, I hope, they will tell their workers to go back to work. Is anybody else has anything to add on this topic? And Mr. Rosenberg, you have to withdraw your, you never got a second. All right, so let's move on to the next
Actually,
topic.
through the chair, I do have some questions.
Yes,
And
go ahead, Mr. Schwartz.
obviously, the new wording of the contract, wording of the new contract has significantly changed from last year based on the, whether you call it the interpretation of the law or outright what the law clearly says. Some of the questions that have been thrown my way was, some of the things that are written in the law, is that subject to somebody's interpretation, or is everything written in black and white? And is it just simply that things were done correctly last year, as opposed to having an alternate interpretation of the law?
I think all laws, as you know, are subject to interpretation. That's what keeps us lawyers in business, right?
That's why we have so
The
many.
state has issued their interpretations of some of these laws, and they're holding the pocketbook, as you know what I mean. So,
Have they issued it in writing,
So
Mark?
that's my question.
have they issued it in writing?
Yes,
I don't-
any
I have-
changes in the IDA contracts, are any changes in those laws were written by the state in writing?
What changes are you referring to?
You're talking about the 192 compensatory education services contract. That's the one that
Are
they...
you referring to IDA?
No, I'm not, no, let's continue where we are now. You're saying that there were changes as far as the laws are concerned, and that this contract for the IDA was significantly changed.
No,
But I'm asking,
I don't think the IDA contract was significantly changed. I think he's referring to, correct me if I'm wrong, Mr. Schwartz, the 192.
Well, I'm referring to both actually, because
We were discussing
my
the
understanding-
IDA contract.
I'm sorry. My understanding is that the IDA contracts should have been sent out a long time ago, and they were pulled and
they were
withheld.
what?
They were withheld.
By whom?
I don't know. That's my
Well,
question.
we just heard that the reason is we're understaffed in the business owner. That was very loud and clear, and I think the board is making a commitment to make sure. I'm happy to hear it now, but I think the board is happy to make a commitment that we will address it.
But I understand there were some changes in the language of that contract as well.
I spoke to the attorney at the law firm. There was some language change, and Ms. Winters, please correct me. He said one of the things that as I went with him through every single contract, just to see what changes were made, what's being sent out, and he told me that one of the changes in the IDA contracts was the language that the state auditors required in the Title I contracts, but by law, you do not have to have them in the IDA contracts, but he said that the district requested that they should be put also in the IDA contracts, and those requirements are documentation from the parents in terms of whatever they need to be. So that's what Ms. Winter said, that all of that was addressed, and all the documentation that the parents need to submit to comply with IDA contracts, or the schools, or whatever that is being compliant. So based on what Ms. Winter said, we're just waiting for the signature of the vendors. Is that correct, Ms. Winter?
I think you mean the schools, not the parents.
Yeah, the schools, I'm sorry.
Yes.
All right, anybody else on the topic of IDEA?
Okay, Mr. Slavkin, I don't
Yes.
think you answered my question.
I don't think it was directed to me. Please go ahead.
Well, you tried to answer my question, so I'll direct it to whoever can. In IDA, there was some specific language that was changed, and I'll give you an example that the paras need to be highly qualified. Is that a directive from the administration, or is that coming from the state based on the letter of, the intent of the grant?
Mark?
Was that one of the changes?
I don't know I don't know that particular change. Ms. Winters may know it. We made changes to the contracts based on recommendations made by Ms. Winters. She might be aware of that one. I don't know that one in particular, Mr. Schwartz. I can't answer that question right here and now.
Ms. Winters, can you address that, please?
No, I believe that was changed. IDA does not have to be highly qualified.
Is that 192?
Well, we're not talking
No, that's IDA, we're talking about IDA.
It does not.
Title I has to be highly qualified, IDA does not.
Mr. Schwartz, was the question answered?
And so if that's in the contract and it's not the law, we'll obviously talk to the vendors council and we'll do what we have to fix it. So again, there's sometimes back and forth on these issues.
So again, just
Mr.
to...
Roselli corrected.
What's that?
Joe corrected.
Oh, was corrected?
Just to make
Okay.
sure that this board is committed and fully committed to comply with all laws, but we want to make sure those laws have been communicated by the state officially to the district in terms of the audit, and we take the audits very seriously. And let's move on to the next topic, which is we'll discuss the Title I 192 services. Ms. Winters, if you could shine on the light on what is happening with those services.
Is that 192?
Yes, 192 and Title I.
That's supplement versus supplanted.
Yes, if you could just explain to the public. They came here to hear, they heard some concern. If you could just elaborate, who is it affecting, how is it affecting?
Well, with Title I services, you have to supplement the service, not supplant it. So you cannot service a student during an English class or a mathematics class. It has to be in addition to a math class or in addition to an English class. So it cannot be during a core English class or a core mathematics class.
How about any other social studies, anything aside from math and from English?
So can you provide a student Title I service during a science or social studies class? That would be a district decision. So Mr. Zara and I spoke.
Is that the law?
One second, time. Let the superintendent know.
So as a district decision, it was decided that Mr. Zara and I spoke, and we decided that you can take a student out and provide a Title I service or a comp ed service during science and social studies.
So just one second.
Wait, no?
Go. Yeah.
No, we have not decided that.
Okay, we did not
Okay,
decide
so
that.
the superintendent said that I just want to clarify,
The
your
regular
position.
program includes science and
Okay.
social.
Mike, let me just sir, please, let's just go through. So you are saying,
Weren't written specifically for private.
okay, Mike, let's just go through the Title I 192. Ms. Winters just said that the position as a superintendent, she feels that the services.
No, look, Mr. Zara.
So you're reversing your opinion based on Mr. Zara?
No, I'm not, I do not.
I'm just asking, I want to clarify. Go ahead. So you
Okay.
feel that the children cannot be taken out during the science? I just want to I'm just trying to clarify, that's all. If you could clarify your position as a superintendent, because and the public needs to know, a lot of those decisions are left in the hands of the districts. And districts across New Jersey make different decisions in terms of how they do any type of service, as long as they comply with the state laws and regulations. So as a superintendent of the Lakewood districts, you are saying that we can or we cannot provide 192, we cannot take out the child for math of 192 during science or history.
You cannot supplant. So
you feel that I'll give you a chance, I just want to make sure that my question is right.
I think you're trying to twist my words. Stop.
No, not at all. And I want to put it on the record that I'm not. But I just want to hear your official position in regards to 192 and Title I. The children are allowed to be taken out to be comp ed, to compensate for something they didn't learn because they have a learning disability, obviously.
I'm not going to explain combat. Title I will explain,
Right.
you cannot. Mr. Zara, if you can explain
But can you state your,
Supplementing, I did not speak with the state.
but can you state your position as a superintendent of the district? What do you feel in terms of providing enduring science of history?
No, I cannot. You cannot take it out, George. The state said you
Got
cannot
it.
supplant.
All right, that is your position.
See,
To the chair, thank you for clarifying, yes.
is this, I think that maybe correctly, Joel, is this the law or this is up for interpretation?
New Jersey code, not law, let me try that again. New Jersey law defines what is compensatory education services. It uses the word supplement, that they're supposed to be supplemental. It doesn't use the word supplant. Title I does use the word supplement, not supplant. So New Jersey law does not use the word supplant. So to Mr. Schwartz's point earlier, I think some of these laws and regulations are open to various interpretations. It talks about an integrated program. An integrated program to me is, it could be a push-in program where you have a teacher come in and work with a student who's struggling and that sort of thing. I understand the state has taken a different position. Mr. Azara spoke to various officials of the state. I don't want to put words in his mouth or their mouths, and he can certainly tell us how they're interpreting it, because we have to be concerned if they're not interpreting it the way we are, that I don't want them to cite us in a future audit or make us return state funds. So
I think you're making a good point. I think it's
First
a
of
point.
all, we had no objection to pushing programs as long as the teachers were servicing only eligible students for the services, and they were working with the individual students or in small groups in the regular classroom. It's the pull-out. It's when you pull a student out of the regular program, the same program that he's having difficulty in, 2 days a week, when it's only delivered 4 for remedial services, the child's just getting farther behind. The remedial services are supposed to help him accomplish and stay in that regular program. And that is supplanting. And that is that's the department's position. Now, the department, when they, if you want to challenge the department, you can have Mark file ask for a declaratory judgment from the commissioner. When the audit comes out, I'm sure they'll be citing it, because the audit for 192, 193 is in process. You can challenge that at that time.
All right. So Mike,
If you want to continue to do something that the department's telling you is a violation, you're jeopardizing your funding.
Okay.
And unfortunately, the funding is going to come out of the public school budget.
So Mike, let's just clarify what you just said. You said that you just said that the Department of Education is instructing the district to do services in a different way that's being provided. And my question to you, we had 5 auditors from the state. They've been here, and I believe they were senior auditors. They've been here for 18 months looking through all the programs. There were 54 pages. Not in one page did they cite, and remember, they were here for 18 months. Not in one page did they cite any issues with the way 192 was provided. Not in one page. These are senior auditors.
Isaac,
Mike, I would like to finish.
that was a
Mike,
consolidated monitoring report.
Mike, can you finish?
It was not an intensive audit report, which is in process, and I've told you it's in process.
Okay, so you're saying that there's different...
So I don't know why you're trying to mix apples and oranges.
Okay.
You're obviously doing it for your own benefit.
Mark, let's work out in a respectful environment. Don't make accusations. I mean, you're the one that
Today I met with a number of rabbis who control the majority of schools with the majority of students. And we are going to meet in Trenton next week with the various administrators who handle Title I, who handle Chapter 192, 193, and who happen to handle IDEA. And I had tried to set that meeting up for this week,
That is
but I never got any response back the last 3 weeks on what dates. And that was what you had agreed to do, Isaac.
And I
And
did
now
agree.
today, I had to meet with those rabbis personally to get them to agree to a meeting in Trenton where we can hash all this out.
Look,
And that's what we're going to do.
I have asked for the same meeting. Rabbi Mendelbaum, did I ask for the same meeting? I asked, Rabbi Mendelbaum was nodding, that I have asked the non-publics to meet and try to work a compromise. I think I've done over dozens of meetings with the state officials on all levels to try to work compromise on busing and everything and any other issues. So I think meeting is good, and I commend you for your accomplishment today. But I would like just to understand, Mike, and that's all we're trying to do. We're trying to understand.
Isaac, I've been here since May, and I've been trying to work with you with all these issues. The very difficult issues. Issues that even the district's administration didn't really understand. And this is a tough task for everybody. And it has millions of dollars on the line that we get it right.
I understand.
And that's what I'm trying to do.
Right, but what I'm trying to
And
do.
every turn, I've been finding resistance from the non-public school sector.
So you got resistance, so, all right. Let's, Chair, one second, Mike, I just want to understand, who is the one at the Department of Education? Because we have, the district has not received anything in writing. Please tell us, who from the Department of Education, based on what documentation? Because he said, you just before said that 192 is in process. So what, based on what documentation, and please give us the names of Department of Education. The public has a right to know, these are public officials. Who in the Department of Education made the decision that the way that schools are doing it now is wrong? And I'm not an educator or an attorney. I don't know how everyone does it and what is legal or not. I've been elected here, and I'm asking you a question. Who in the Department of Education issued this, is it in writing? Because we haven't received anything. And I want to say something else. There was a non-public consultation in Trenton this year. There were over 50 slides. The only slide that mentioned supplement was 193. The 192 did not mention. The person who presented the 192 did not mention anything about 192 having problems with supplemental Lakewood. And at that meeting, they did discuss Lakewood. So I'm asking you again, who is it coming from?
Dr. Karen Campbell.
So Dr. Karen Campbell made the decision.
John Worthington.
Okay. So they made the decision that, and it's based on what documentation. Did they go into the schools? Did they know who gets pulled out all the time? And I'm just asking a question. What has been communicated to you? What is it based on?
It's based on the interpretation of the supplement, not supplant law and case history.
So were they suddenly just out of the blue made aware that there's an issue with supplanting and supplementing after, again, I'm not trying to discuss what's legal and what's not legal. I'm simply asking, were they made aware by any individuals that somehow that there's an issue with the supplanting and the supplementing, or just out of the blue they decided to make this ruling? And why didn't they send it to us in writing, like Mrs. Latkin said?
The Title I audit, okay, identified areas of supplement supplant. The people who were in here doing auditing, but they haven't finished their audit yet, had indicated there are issues with supplement supplant. I was trying to prevent the district from having to send back any more money. And I contacted the district because we met with non-public administrators and with some of the rabbis, and they were very contentious about the issue of supplement supplant. And I told them, I will check with the department to see if there's any flexibility. I called the department. I had a conference call with at least 4 or 5 people, but the major decision makers were Dr. Karen Campbell and John Worthington, and who's an attorney. And they said that pulling students out of a regular program for comp ed or other services is a supplanting situation. My only option is to enforce what they tell me. If when it comes to a decision where the audit comes in, if you want to continue doing it, you're jeopardizing your money. When the audit comes in, if you want to challenge it, be my
Please don't take
guest.
my words out of context. I did not say that we should continue providing services from the state if the state is the one that has the person
Nobody
without
said that.
authorization.
No,
That's not
on the
my
record,
point.
nobody suggested that.
Nobody suggested that. Please let's not put words in people's mouth. Well, my only point was to find out who at the Department of Education, because we have nothing in writing. That's why we're asking all this question. The only one we heard it from is from you. So we're asking who is the one, and you said that you are trying to talk to them. It seems like you're advocating for Lakewood. So we're trying to understand who is the Department of Education is doing this.
Through the chair.
Yes, go ahead.
I'd like to repeat that motion that I just made, but before that, what is apparent is that, what's definite is that the kids, A, don't have nursing, IDA has been cut, 192 has been cut, there are no textbooks. What's going on behind the scenes, we don't know. But what we do know is that things that were never an issue in the past, all of a sudden this year turned into one catastrophe. And while I don't practice law, and we have Mark Zimmer as our lawyer, it's my understanding that there are, like we're discussing here, that not everything is black and white. There are some districts that maybe understand Common Core differently than other districts, and it's not black and white. And that's something that I'd like to put a motion, and that is the contentious issue here, of if you can pull the kids, if you can, among other issues. And so I'd like to make the motion to continue that service as in the past, and if there is an issue that somebody in the state maybe is saying that the rules have changed, although it's not on paper and have changed, then we should hire, we, the Board of Ed, the kids of Lakewood need these services. And the kids of Lakewood need these services. They're not being provided. Us as a Board of Ed will vote, or I would like to put a motion to get these services running tomorrow, as have been in the past. If someone in the state feels that the rules have changed, let them come to Lakewood and change those rules. I'm not done.
Okay, you're done.
Okay.
Let me finish. Now you're done.
So what I do know, Mr. Azara, coming from Camden, that you definitely cut, what's apparent to me is you definitely came with a pair of boxing gloves. You definitely left your heart in Camden. And I'd like to make a motion to give these kids. I'm not sure how one can have a heart and know that schools are opening without textbooks, not email anybody, that the services are being cut and nobody knows what's going on. But they're waiting for emails that the non-public
You cannot disturb a public meeting. You cannot disturb a public meeting.
Okay, now it's okay, now it's okay. Listen.
There is a portion for recognition of the public. There is a portion of the meeting for recognition of the public. The public has a chance to say. Right now we're conducting a board meeting. Please, let's have the board chance.
So once again, I'd like to make that motion to continue all services as was last year. If someone in the state feels that's illegal, it's not been written.
Thank you, Pastor.
Nothing has been told to us. To us as the Board of Ed, we're going to vote it through as it happened last year. I would put a motion on to vote the services through as happened last year, contingent on last year's contract. Through the chair.
Yes, go ahead, Mr.
We just heard the state monitor say that a lot of things that we were doing in the past were not in compliance with state and federal law. Why do you keep saying we should do things as they were in the past?
Well, I think the board made it clear that we are hypersensitive. Let me repeat it again. Hypersensitive to any type of compliance issue, and we are on the forefront. I know that Ms. Winters herself told me that, in mentioning some specific schools, that they're calling and the secretaries are calling and saying, how do we comply? Tell us. And they're complying and they're asking for more information. Ms. Winters, please correct. Is that true? That's correct. So the schools and the board, and I disagree with Mr. Azaro, who said that the school are resistant to changes. You have a superintendent here saying that the schools are calling to comply with all the regulations. With all the orders. I agree. Why are you saying, you have a superintendent here who says that the schools are complying, the schools are calling, why are you saying that the schools are resistant to change? Are the schools have to walk in line for everything? They cannot disagree or present an argument? Why are you blaming our community? Why are you trying to present community and presenting it that they're are resisting the changes like they're trying to break the law? You have a superintendent that says that the schools are trying to comply and polling intensely. One of the examples specifically I remember, Ms. Winters, you told me about Ms. Tova, who is trying to comply.
I agree. Mr. Rosenblatt made a motion.
One second. I would like to...
Hold on a second. Mr. Rosenblatt made a motion and I seconded it about a half hour ago. And it was never a roll call. Can we just call this roll call and see what the board has to say?
I'm not sure what the motion is. Please read out the motion again.
Read out the motion for the 10th time.
I mean, we had a motion,
I'm repeating the motion. The motion is to continue services as was based on last year's contract and till a new contract that works with the law, once it's defined, but that should not stop the kids from getting services tomorrow.
Mr. Rosenberg, we agree with the letters of intent.
Second the motion. Roll call, please. Second the motion, roll call.
The motion's been seconded.
Who's the second, please?
Mr. Friedman.
Friedman?
Please call the roll call.
Clarification?
We're in a discussion forum. I'm trying to understand the motions. We decided before that tonight, letters of intent will go out to all the vendors, and all the vendors will provide services.
They can still do that, and if they want to go ahead with that, they can sign that. But if they don't, the kids will be getting services based on our vote tonight.
The vendors indicated that they get a letter of intent. Mark, correct me if I'm wrong. The vendor says that, time, please let me talk. The vendor said that if they get letters of intent, they will start providing services.
That doesn't stop us from making a motion. If they'd like to sign a letter of intent and provide, it's not one against the other. We can pass this motion and let them sign a letter of intent tonight.
So you're going back to your original motion that
Correct.
contracts should be provided based on all contracts not pending, but obviously with attorney review to make sure that they comply.
I didn't say with attorney review, not contingents of any.
Well, Chaim, with all due respect, the contracts need to comply with the official audit and official what's been said in writing and for what the district gave money back. That has to happen. We cannot take money more and give back to the state.
I'm not saying give more, but some of these
So
items
you
that
are agreeing, so
are
you-
not black and white should be thoroughly investigated. What other districts do,
So that's
it's not
more-
black and white.
And are you living? So that's what I'm asking. Are you living to the opinion of Mark? What has to be complied based on the auditor's reports, and what he feels does not have to comply? Are we living it in Mark's hands? That's a
Yes.
question. All right.
Yes, fair enough.
All right. So it is comply with all the previous auditors' reports and everything else, and leave all areas that are not conclusive in the hands of Mark, the attorney.
Great,
Is
roll call.
that the motion?
Yes.
Can I hear
What do you
the,
say?
can I hear the exact motion again?
Please repeat the other motion to the...
The motion is to continue services based on last year's contract until a new contract is given, and everything will be paid according to last year's contract, so long that it is legal, determined legal by our attorney.
Second. Roll call.
Mark, one second, Mark, can you sign in? That is based on your review, and the letters of intent go simultaneously. I mean, the motion is that it should go together, and...
That's fine. As I had said earlier, I think the letters of intent would be sufficient
All right.
based on the communication.
All right, so let's have a vote.
Mr. Friedman?
Wait a minute, what
Yes.
vote do you want to get? You keep having a conversation, now it's the letters of intent, or is it later?
The letters of intent is something we discussed previously. That's something that we got a commitment from you and Laura that the letters of intent will go out tonight to the vendors, so the schools will start tomorrow.
Are you
with all the
withdrawing the
services.
motion? Is the motion
The
being
motion
withdrawn?
is a separate motion made by Mr. Rosenblatt that has to do with contracts, and basically there's no all contract. It will be all contracts with attorney saying how you comply with the new regulations, and based on that, it will be compliant. Mark feels that the letters of intent alone will be enough, but there's a motion on the floor by Mr. Rosenblatt. Mark has the exact language of the motion, Mike, if you would like to see it.
Please read it.
Okay, can we have a roll call so we can move on and give...
We're in the middle of a roll call right now.
Yes. Roll call, please, Tom.
Mr. Friedman,
Yes.
Mr. Jankovich, Mr. Rosenblatt,
Yes.
Mr. Schwartz,
I'm not going to vote on this motion. It doesn't make sense.
Thank you. One thing,
The letter of intent should be enough for the vendors. And if you vote on this motion, then maybe paying it based on last year's pay scale also, which the vendors would definitely not agree to. So I think it will just confuse the vendors. I would love for service to start tomorrow. I hope the vendors will accept the letter of intent and will put it behind us.
thank you. Yeah, stupid motion. Anyway, it was stupid motion.
I'm going to abstain. I'm not going to vote now. I'm going to abstain from this motion.
He is abstaining. So you're not against it. Okay, continue.
Of course I'm not against it.
Mr. Silver, Mr. Tiff.
I have to agree with Joel. I'm not against services being provided. Trust me, no one up here on this board is against services being provided. But the main reason is why we're here is to make sure that we're in compliance with the law.
Well, but Mark said there will be compliance.
And based on the contracts, based on the good faith that these vendors, why wouldn't they want to provide services? Because these providers have been with these districts for years. They didn't just start with this district a couple of years ago. They've been here for a long time. They've been providing services for these kids for a long time. Why would they just want to just pull these kids out based on, them reviewing their contracts? I'm sure they have lawyers at these schools. Can I please finish? I didn't know anybody.
Go ahead. I'm apologizing.
Talking up here.
I apologize. Go ahead.
We need to be certain that, and like I said, no one up on this board wants to see